So in this video, I'm going to try to explain everything I think you need to know about divorce. The first thing I want to mention to you that you might not know is that there is a restriction on applying for divorce within the first 3 years of your marriage. Not a lot of people know that. And so if you get married today, you can't apply for a divorce until you've been married for 3 years. Now that differs from jurisdiction to jurisdiction, but in St. Vincent, there's a restriction for 3 years. So you want to keep that in mind before you get married. If you get married to somebody, keep in mind you're going to have to stay married to that person for at least 3 years. There is an exemption though. You can ask the court to give you permission to present a petition before the expiration of 3 years, but it must be under exceptional circumstances. And so the law provides that you can apply for permission on the ground that your case is one of exceptional hardship or of exceptional depravity. And so the court would give you permission only if you are experiencing exceptional hardship, and you have to prove that to the satisfaction of the judge. And when that application is made, the judge will have regard to the interests of any child of the family and to the question whether there is reasonable probability of a reconciliation between the parties during this 3-year period. And so that's something that you want to keep in mind, right? And that is important not only because you have to make an application for permission or for leave to present that petition before the 3 years has elapsed, but there's also a cost factor in making that application as well. So you want to keep that in mind. So if you are looking at this video and you are considering getting a divorce, the first thing that you want to do is to find your marriage certificate, or if you recall the date of your wedding offhand, you revisit that and see if 3 years has passed since you got married. The second thing that you want to keep in mind is where you live. And so the laws of St. Vincent and Grenadines stipulates that in order for you to apply for divorce in St. Vincent and the Grenadines, either you or your spouse must be domiciled here in St. Vincent. What does domicile mean? It basically means you are ordinarily resident in St. Vincent. And so if you are overseas but your spouse lives here, you can apply because your spouse is domiciled here in St. Vincent. If you're in St. Vincent and your spouse has migrated to another country, you can apply for that divorce here in St. Vincent, notwithstanding the fact that your spouse no longer lives here, right? However, if neither of you are living in St. Vincent, you cannot apply for that divorce here in St. Vincent because you guys no longer live here. So let's say you're both Vincentians and you migrated to Canada 10 years ago. You can apply for that divorce where you now reside. You're just going to have an original copy of your marriage certificate. And so that's one of the reasons why keeping that marriage certificate in a safe place is going to be important, because if you migrate, you're going to have to apply to have that original copy released to you or an agent of yours, and then there are courier fees involved in getting that marriage certificate to wherever you are now living. So that's something that you want to keep in mind. You can apply for divorce in another country, notwithstanding the fact that you got married here. So if you think about it, it makes sense because the destination weddings are a thing. And so let's say you decided that you want to get married in St. Lucia, and you and your now spouse flew out to St. Lucia for that wedding, but you guys came back to St. Vincent. The fact that you got married in St. Lucia does not mean that you can't apply for that divorce here in St. Vincent. Point is, you guys live here. Now, the next thing that you want to keep in mind, now we're talking about where you guys are living. The law says that the petition for divorce must be served on your spouse personally, which means wherever they are living, they are going to have to receive that petition. And so you're going to have information as to where they live. You're going to have their address. So if they live overseas, you can mail that petition to them wherever they are. right? So you're going to have to know at least where your spouse is living if you are to apply for that petition, or to have some information as to how they can be located, right? So you have cleared those initial steps. You've been married for 3 years. One of you is domiciled here in St. Vincent. You know where your spouse is living to effect service of the petition. What is next? The law in St. Vincent and the Grenadines stipulates that you must have a reason for applying for divorce. And so we call it a fault-based system. In some countries, you don't need to have any reason for filing for divorce. Here in St. Vincent, you have to apply for divorce under one of 5 grounds. And those grounds are: 1, adultery; number 2, your spouse has behaved in such a way that you can't be expected reasonably to continue living with that person; number 3, you have what is called 2 years separation with consent, which is to say you and your spouse have been living separate and apart for a period of 2 years before you apply for divorce, and your spouse consents to a divorce being granted. And so under that ground, they must actually sign a consent stating that they agree to the divorce. There's also a 4th ground called 5 years separation with no consent. So in circumstances where you and your spouse are living apart, but they are not minded to consent to the divorce, you have to wait 5 years before you can apply for divorce without their consent. And the 5th and final ground is desertion. Basically, your spouse deserted you, and they must have done so for a period of 2 years before you apply for that divorce. There is also what you call presumption of death. Now, we all know that marriage is until death do us part. And so if your spouse dies, that's the end of the marriage. But there are, rare circumstances under which your spouse, you don't have any concrete evidence that your spouse is dead, but you can presume them dead based on certain circumstances. And so that is another ground that you can apply on. Very rare, again, but it's there. But the first 5 are the 5 main ones that we're talking about. Now, there are certain considerations that you want to keep in mind in relation to these grounds of divorce. In particular, the first 2, adultery as well as behavior. Basically, if you are relying on the ground of adultery, your spouse has cheated on you and you found out about that adultery, but having found out about that adultery, you continue to live with your spouse for a period of 6 months, whether 6 consecutive months or periods of time that taken together add up to 6 months, you will not be allowed to rely on that ground, because having had that knowledge of adultery, you continue to live with your spouse, right? So it's not just adultery, but you have to find it intolerable to live with that spouse, having knowledge of that adultery. And same applies for, your spouse behave in such a way that you cannot reasonably be expected to continue living with that spouse. If after the date of that last incident that you are relying on, you continue to live with your spouse for a period or periods of time that total 6 months, again, you will not be able to rely on that ground of that behavior, right? So these are things that you want to keep in mind when you are deciding on which ground you wish to proceed on, right? And when it comes to living separate and apart does not necessarily mean that you guys no longer reside under the same roof. You can be living under the same roof but still be deemed to be living separate and apart, because there are persons who live in the same house, but for all intents and purposes, they are not cohabiting together as husband and wife. And so you can meet that 2-year or 5-year requirement under living separate and apart, even if you guys are still living under the same house roof, right? So generally speaking, Those are the 5 grounds under which you can apply for divorce. If you followed me on those grounds of divorce, you would quickly realize that if you are applying for divorce, you can get divorced even if your spouse does not wish for you guys to get divorced, right? Only under one of those 5 grounds was consent mentioned. And so if you want to get divorced but your spouse does not want the marriage to end, you can apply for divorce, notwithstanding the fact that they don't want the divorce to occur, right? So don't believe that, unless they sign the papers, as you would usually see in the movies, you can't get divorced, right? So that's one in relation to your partner's consent. There's also the issue of once that petition is solved, your partner has the option of filing what is called an answer and cross petition, which essentially means that having laid out the evidence in your petition where you are, putting forward evidence to the court to prove that your marriage has broken down irretrievably, they can file an answer to that petition to say, look, the facts as alleged by the petitioner are not true, and they can file that answer to basically challenge that decree being made. And they can also file what is called a cross petition, which is to say they are filing a petition of their own, alleging their own facts as to why the marriage broke down irretrievably. That is what you call a contested divorce. I don't want to say that those contested divorces are rare. They do happen, but what I can say is that in the almost 7 years of my practice, I've never actually done a contested divorce because I just figure it's a waste of time. If there's a marriage and both parties want out of the marriage, I don't see any reason why you should be arguing and fighting over, whose fault it was or who should go down on record as the one filing for the divorce and what facts are established as true. At the end of the day, it's going to be the same end result. Both parties want a divorce, and if divorce is what you both want, at the end of the day, the reasons put forward and who is at fault is really not significant unless there are other ancillary matters like property adjustment orders that would come later down, and you wish to rely on that person's conduct when you are making applications for a property adjustment order. But as far as the divorce is concerned, contested divorces, I think, are a waste of time and money, right? So before you file for divorce, you want to have a conversation with your spouse. You want to, let them be aware that, look, I'm going to be filing for divorce, so that when that time comes for them to be solved with the petition, they're not surprised by it, that you guys have already sat down and had a conversation about it, they're expecting it, and you guys come to an amicable agreement as far as property and minor children are concerned. Having those conversations will make the process of divorce so much easier, so much cheaper, and so much less time consuming, right? So it's not advisable that you surprise your spouse with a petition for divorce. It's not really a good thing to do. Or have a bailiff serve divorce documents on them at their workplace, right? You want to go about this in the most sensible and sensitive way possible so that you can get through this process in the least amount of time and the least amount of expense. Right? So that's something that you want to keep in mind. As I mentioned at the start of this video, there are matters that we call ancillary matters that must be dealt with before the divorce is finalized. These matters refer specifically to minor children, and minor children here refers to children under the age of 16 and under, or if they're over 16, they must be enrolled in an educational institution or undergoing some training in a vocation, for instance, right? In those circumstances, the obligation to maintain those children continues during the duration of their time at that educational institution, right? So satisfactory arrangements must be made for those children in relation to legal custody, access, Access there refers to, the partner who the child does not live with, having access to that child, whether it's visitation rights or whatever the case might be, as well as maintenance. And maintenance here can refer to maintenance for the minor child. It can also refer to maintenance for spouse. There is provision in Vincentian law for spousal support, right? So these issues must be dealt with before the divorce is finalized. Until those matters are dealt with, the divorce will not be finalized. Why is that important? That is important because if you wish to remarry, it is a criminal offense for you to get married to somebody else while you are still married to your current spouse. And I can let you know that the maximum penalty for bigamy, which is essentially being married to two persons at the same time, is 7 years imprisonment. You can be charged on indictment for that offense. And so this is why I encourage persons, if you are married and you, for all intents and purposes, that marriage is over, you guys have separated, you've moved on with your individual lives, it's also a good idea to bring an end to that marriage legally, so that if you bounce upon somebody else and you want to get married, you can go ahead and remarry without the fetter of divorce proceedings, because people tend to underestimate how long the process of divorce can take from start to finish, right? The fastest I've ever got through a divorce was 6 months. And this is a divorce where there are no minor children, there's no property involved, there was consent, everything was amicable. 6 months, right? That's the time frame that you're looking at. When it becomes contentious, not just in terms of the divorce, but where there are issues of minor children to deal with and property, you are looking at 1 year, and it can extend for, there are some divorce applications that are before the court and languish there until children reach the age of majority. That's how long these cases sometimes end up before the court, when parties are not willing to come to any amicable agreement or settlement, or those matters go to trial, and going through the high court system can take a very long time. Back and forth and getting sometimes export reports, visits, getting evidence and that sort of thing, right? Now, you can appreciate that if you want to get married within a particular time, there's really nothing that you can do to fast track that process to get married in the time that you contemplate. And I'm mentioning this specifically because persons have a habit of coming to a lawyer when they already have a boyfriend or a girlfriend or a fiance. They've set a hard date when they want to remarry. They've started spending money on the marriage or starting spending money on building this new life together. And then they come to a lawyer to get a divorce and put pressure on that lawyer to get a divorce done within a particular time period. It is almost well impossible. And no lawyer, however experienced, can give any client a definite time period as to how long it's going to take when there are contentious issues at play concerning minor children and property. So this is definitely something that you want to keep in mind, even in circumstances where you tell yourself you are not going to get married again, right? Even if you don't wish to remarry, you still have to consider estate administration in the event that you die without a will or without a valid will, how your current now estranged spouse would stand to administer and substantially benefit from your estate, as well as how not getting married can affect provisions that you probably currently have in your will, right? So these are things that you want to, keep in mind when you are deciding whether or not you want to get divorced, right? And as far as the cost is concerned, divorce can be very costly. Um, I had one client say to me one time that, getting married is so cheap because really, you really only need to spend $15 to get married. That's to apply for your license. But divorce, at least now, starts, this is uncontested, starts at 3,005. And when there are ancillary matters involved, an ancillary trial where there's no agreement can go up to 7,005 if there's a battle over minor children and property, right? So could be very costly, but as I mentioned before, having a conversation with your spouse, coming to agreements on matters that you can come to agreements on, I can't stress that enough, will save you considerable amount of time and money. And so you want to ensure that you have these discussions before relationships deteriorate to the point where there's no communication, absolutely no communication between the parties, because we deal with that all the time, where parties don't talk to each other, parties don't even know where their spouse is. And when relationship deteriorate to that point, coming to an agreement is sometimes extremely difficult, if not impossible. And to end this video, I'm going to advocate for reconciliation. Might sound strange coming from a lawyer who does divorce cases, but you don't want to get divorced if you don't have to, right? If it is possible at all that you can reconcile with your spouse, I advocate for that very strongly, and I encourage young couples to do premarital counseling as well as marital counseling if you encounter any difficulties in your marriage, because some marriages can be saved, and if yours is one such marriage that could be saved, by all means, save it, because divorce does have that potential to affect you, not only financially. So I don't want to make it sound like it's really only about the finances, but just simple matters like seeing your child every day. Tremendous changes will take place in your life. So that's been it for this first video for 2022. Let's hope that let's hope that you don't end up getting divorced this year. But if that happens to be you, then at least this video gives you an idea as to what you want to keep in mind when you are making those decisions. So thank you very much for watching, and I'll catch you guys in the next video that will release next Monday, where we'll talk about those ancillary matters. What happens with those matters? Is it 50-50 split with property? What happens with my children? What about spousal maintenance? Those kind of issues. We'll talk about it very briefly in next week's video. So you definitely want to subscribe to the channel and stay tuned for that one. So do enjoy the rest of your evening and have a pleasant week.